In this video, we're looking at equality rights in Canada. When we talk about equality rights, we're trying to address discrimination between groups. We're looking to see whether there are laws that are discriminatory. Are they treating people differently? Are they treating groups of people differently? And is that treatment discriminatory? That's essentially what we're looking at. Now in Canada, there's been two different legal regimes around equality rights. Before 1982, and then after 1982, once the Charter of Rights and Freedoms was in force. In the before times, before the Charter, there was lots of discrimination. There were laws that discriminated against women, different religious groups, and different political viewpoints. Now, from time to time, the Supreme Court would strike those laws down. One law was struck down, the padlock laws in Quebec was struck down, targeting communists. Another was struck down because it targeted Jehovah's Witnesses. But they weren't struck down on any basis of violating equality. Rather, they were struck down because they were ultra vires. The Supreme Court said that the power those laws produced should have been the prerogative of the federal government. Provincial governments couldn't do that. So they weren't doing it based on equality, just that it was outside of provincial jurisdiction, ultra vires. There was no guarantee of equality in the Constitution. Until 1982, then we have the Charter. Section 15 guarantees individuals equal protection of the law, equal benefit of the law without discrimination, and it lists a bunch of different categories of people that are guaranteed rights. There's also Part 2, Section 15, gives the federal government the ability to ameliorate the conditions of certain disadvantaged groups. So they could essentially pass laws or regulations aimed at fixing harm that was created in the past or groups that have faced historical discrimination. Now, if you find that confusing, you're not alone. Think about it. Section 15.1 says you can't discriminate. It's bad. Section 15.2 says, sometimes you can. The idea being that if the government wants to fix past discrimination, the laws and regulations that it might implement would be technically discriminatory. But Section 15 Part 2 gives them a pass. It allows them to do that without violating Part 1. How does it work in practice? Well, the first time that Section 15 was put to use was Andrews versus the Law Society of British Columbia. It was a case where a person, Andrews, claimed he was discriminated against based on his citizenship. Permanent resident of Canada, lived here for a long time, wanted to work as a lawyer in BC, wasn't allowed to. Under BC law, you wanted to practice law, you had to be a citizen. Well, he appealed that and it made it all the way to the Supreme Court. And the Supreme Court had never really looked at an equality case under Section 15, so they had to figure out what they were looking for. Now, in parsing that, it's possible that just looking at the words on the page wouldn't be sufficient because it might guarantee equal treatment, but it could produce unequal outcomes. And so the court wanted to focus on something they called substantive equality. Was there really unequal outcomes or condition based on the way the law was used? They also needed to come up with a framework for analyzing Section 15. Never been done before, so they came up with sort of a two-pronged analysis. Does the law create a distinction? And is that distinction discriminatory? So in this case, it would be, does the law create a distinction based on citizenship? And is that discriminating against people without citizenship? But citizenship wasn't one of those things on the list. It wasn't one of the enumerated grounds that those were itemized in Section 15.1. Race, national, ethnic origin, color, religion, sex, age, mental or physical disability. Citizenship isn't on there. So what should the court do? Well, the court ruled that that was analogous. Citizenship was similar enough to those things that it could count as one of them. And that was kind of the framework that was established, the way courts would approach Section 15. Does the law create a distinction based on an enumerated ground or an analogous ground? As a caveat here, the court tended to focus on immutable characteristics. You can imagine a situation where somebody might claim that tickets to the Toronto Raptors were discriminatory because they were so expensive that they discriminated against people in poverty. The court wasn't going to go there. They were going to focus on immutable characteristics, things like race and language, that you couldn't change easily, that were not really under individual control. Over time, Section 15 has been used In Vryn versus Alberta, a teacher was fired because of their sexual orientation, tried to challenge that dismissal, but Alberta law said, no, sexual orientation is not a valid reason for challenging the law. So he took that to the Supreme Court, and the Supreme Court ruled that sexual orientation was analogous to the enumerated grounds. How we think about that is we say that it was read in to Section 15. So after the court makes a decision and finds something analogous, like citizenship or sexual orientation, we now say that they have been read into Section 15, so that when a future court has to look at this, they now include those among the other enumerated grounds. They're considered analogous. Because of the power of Section 15, the courts are reluctant to use it. If somebody's claiming an equality violation based on religion, they'd rather look at it under Section 2 instead of Section 15 because it could be really expansive. It could get out of control. You could find inequality claims everywhere. So courts are reluctant to apply Section 15. Beverly McLaughlin called it one of the most difficult rights to try and adjudicate, and it's even been referred to as a nuclear bomb, Section 15, because it could be so expansive if it was interpreted so. Just to recap, in Canada, our equality rights are guaranteed in Section 15. The court uses a two-pronged analysis to evaluate whether a law is discriminatory. Is there a distinction created by the law? Does it make a distinction between different groups? And is that distinction discriminatory?